other grounds, challenged the election of the second respondent on the ground that the second respondent presented a forged document to the Independent National Electoral Commission, that the appellants have also a challenge in their appeal, the striking out of their pleadings raising the issue of qualification of the second respondent to contest the said election. Learned Silk also relied on the cases of Nigerian Customs Service Board and Innocent and other cases cited in this judgment. According to the Learned Silk, the evidence required to establish that the certificate presented by the second respondent to the first respondent in support of his qualification to contest the said election is the deposition from the Chicago State University, which deposition did not become available until after the determination of the case by the lower court. He contended that the appellant applicants have successfully explained the delay and difficulties in obtaining the said evidence earlier than now. Relying on Saleh and Abba citations supplied, the Learned Senior Counsel urged this court to resolve the sole issue in favor of the appellants and grant the application. In response to the above argument, the Learned Senior Counsel for the first respondent, A.B. Mahmoud Esse, submitted and urged this court to dismiss the appellant's application as they have failed to meet the conditions for grant of same. He opined that election petitions are sui generis and based on the provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended and the Electoral Act 2022. He stated the three conditions that has to be met before the fresh evidence can be admitted, and he urged this court to hold that the appellant's applicants failed to fulfill the conditions. In this, he relies on the case of Adeleke and Aserifa, Wata and Anyago, UBA PLC and BTL Industries, all citations supplied, amongst others. It is his contention that the appellants were tardy and were not reasonably diligent in their attempt at obtaining the documents which they seek to be received in these proceedings, that having not acted with reasonable diligence, this court ought not to grant the instant application, also relying on Obo and Enable S. Limited. Learned Senior Counsel also drew the attention of this court to the decision of the court below, which has not been appealed against, that the petition did not plead facts in support of non-qualification or disqualification of the second respondent in their petition, and that their efforts to remedy it through their replies to respondents' replies were belated and were rightly refused. According to him, the deposition of Caleb Westberg is irrelevant since the appellants did not raise the issue of forgery at the lower court. And relying on the case of Okwe Kenye and registered trustees of Jude Anglican Church, citations supplied is submitted that evidence not supported by pleadings goes to no issue. Learned Silk further submitted that insofar as the deposition of Caleb Westberg is solely to disdain the certificate presented by the second respondent and attached to his form EC9 dated 17 June 2022, which the first respondent published as far back as 24th day of June 2022, the appellant's complaint in that regard is pre-election matter, which by section 285(9) of the Constitution of the Federal Republic of Nigeria is statute barred. As such, an action ought to have been initiated within 14 days or the publication by the first respondent. He urged the court to so hold. According to Learned Senior Counsel, an allegation of presentation of false or fake certificate is rooted in the criminal offense of forgery, which requires proof beyond reasonable doubt. He contended that the deposition by Caleb Westberg, which seeks to establish a case of forgery against the second respondent without more, cannot ground a conviction for forgery of as proof beyond reasonable doubt. Agi and PDP, Mohammed and Wamako, all citations supplied. Learned Silk argued further that the evidence to establish a case of forgery. Finally, the learned submitted that this appeal, being based on an election matter, where a trial court is to hear matters and deliver judgment, was not the intention of the draftsman of the Constitution to allow and permit the receipt of evidence in an election matter when the court vested with the powers of evidence sought to be adduced in the instant appeal. There being no room to extend time under the pre-election and election appeals practice directions 2023 of the Supreme Court, he urged the court to dismiss the application. In his contribution in opposition to the grant of this application, Learned Senior Counsel for the second respondent, Chief Olanipekun S.A., submitted that this court is without the Constitution of the Federal Republic by the appellants. This court cannot grant this application. That Section 22 and 23 of the Supreme Court Act give power to order 2 Rule 12.1 of the rules of this court, and that can only happen if the lower court still has jurisdiction. Referring to Omubilari and Igbo Asoi and others, and Adegbite and Omosun, all citations supplied, the learned contended that applicants failed to satisfy the 5 conditions enunciated in those cases before this type of application can be granted. According to the learned essay, the failure of the applicants to have validly pleaded facts and documents sought to be received in evidence is fatal to this application, relying also in Obasi and Omuka, Start Oil, Nigeria Limited and Induction, and others, all citations supplied. Making reference to the USA Rules on Civil Procedure, 32A1A, the learned opined that the failure to invite, since the alleged forged certificate is alleged to have been submitted to INEC. It is further contention that Exhibit C and D appeal for the fact that there is no ground of appeal upon which they can be structured, as well as there being no accommodative issue for determination, relying on a number of cases listed in this judgment. Finally, Learned Senior Counsel submitted that Exhibit C, D, unpretentiously attempts to allege a criminal offense of forgery against the second respondent. You find that a criminal offense must be proved beyond reasonable doubt, as provided in Section 135 of the Evidence Act, also referring to the cases of ACN and Nyako and Kaki and PDP. He concluded that the Supreme Court does not have original jurisdiction. Chief Akin Olujimi S.N. counter affidavit of the second respondent, which he alleges consists of legal action 285(6) of the Constitution, which pegs 180 days for the hearing and determination of the election petitions, does not include the Court of Appeal, but only election tribunals. Learned submitted that issue of qualification is for both pre- and post-election matters, referring to Section 137(1)J of the Constitution. He urged the court to grant this application in the interest of justice, as was done in Amechi and INEC and Obi and INEC, all citations supplied. In resolving the sole issue submitted for the determination of this motion, I wish to start from the beginning. And the beginning is the issue of jurisdiction. Whereas the respondents in their various written addresses have urged this court to grant not to grant this application as it is an exercise in futility. They opine that the Supreme Court does not have jurisdiction to look into or act on Exhibit C and D if admitted into the proceedings. The Learned Senior Counsel for the appellants submitted otherwise. I have already summarized their various positions, and I shall refer to them as we proceed. It is elementary to state that the jurisdiction of a court is the authority which a court possesses to decide matters brought before it, or to take formal way for its decision. In an old case of Ogun Makun and Milad Osun State, citation supplied, this court stated as follows: jurisdiction of the court is the basis, the foundation, and the live wire of access to court in adjudication under Nigerian civil process. As courts are set up decrees, acts, laws, and edicts, they cloak the courts with the powers and jurisdiction of adjudication. If the Constitution, decrees, acts, laws, and edicts do not grant jurisdiction to a court or tribunal, the court and the parties cannot, by agreement, endow it with jurisdiction, as no matter how well intentioned and properly conducted the proceedings, once it is incompetent, it is a nullity and an exercise in futility. End of quote. The jurisdiction of a court